In this session, we would cover human rights. What are these, and how are they enforced in the Indian Armed Forces? The other matters that will be covered within this lecture are Armed Forces Special Powers Act and certain case law relative to observance of human rights by the military in India. The two common definitions of human rights are that certain basic, inalienable, and fundamental rights, as well as freedoms that every citizen enjoys, irrespective of the country to which one belongs, may be called or would be seen as human rights, and this is the global approach. They can also be seen as those rights which are universal and belong to everyone, rich or poor, male or female. These rights may be violated, but they can never be taken away because every human being from birth till the end is vested with human rights. And just for information, the term human right was first introduced in the American Declaration of Independence in 1776. While human rights as such, the term may not be known, but the genesis or earlier references can be seen, say for example in Bhagavad Gita, where there was a code of the warriors which said that always protect the weak, be truthful and forthright, be humane, courteous and approach. Fight and embrace the consequences willingly. And in the end, God, give me strength that I ask nothing of you, was the prayer as regards human rights. As of today, the relevant legal regimes pertaining to human rights are to be found in the Constitution, in Armed Forces Special Powers Act 1958, then Protection of Human Rights Act 1993, the clauses and the contents of Army Act 1950, Geneva Conventions Act 1949, which has been incorporated into our domestic law by the Act of 1960, and the Unlawful Activities Prevention Act amendments that have taken place. We spoke about the Constitution of India, and in the Constitution, the word human rights has not been used, but the human rights, their approach, their extent, and what do they mean, this can be seen within certain fundamental rights to which we shall see shortly. Now, these fundamental rights, which now are there on the slide in front of you from serial 1 to 6, are in essence human rights. To illustrate, Article 14, which deals or which proclaims equality before law, Article 19 concerning protection of certain rights regarding freedom of speech, etc. Protection of life and personal liberty, which is in Article 21. Then right to freedom of religion, and these are called religious rights, Articles 25 and 28. There is a right against exploitation, begar, slavery, etc. Included in Article 23, 24, and then the minority rights which also extend to culture and education in Articles 29 and 30. Moving to Protection of Human Rights Act of 1993, its preamble read that it was enacted for better protection of human rights and for matters connected therewith, and that should make it very clear that for protection of human rights in a systematic manner and for better protection, quantitatively and qualitatively. That was the preamble of Protection of Human Rights Act. And this act dealt with setting up of the National Human Rights Commission and the State Human Rights Commission at the level of states, and also the human rights courts. We would leave out the other sections and straight come to section 19 of the Protection of Human Rights Act that deals with the allegations of violation of human rights by the armed forces personnel. And it indicates that on receipt of complaints of human rights by a member of armed forces, the Commission, meaning NHRC, shall either on its own motion or on receipt of a petition seek a report from the central government. Now, this is different than what is the NHRC expected to do in other cases where it can order an investigation by itself. But if the allegation against relates to a member of the armed forces, then Commission is requested to seek a report from the central government, be it whether it is prompted to act on its own motion or it has been moved by way of a petition. But what it is supposed to do is to seek a report from the central government. And after it receives the report, it may either decide not to proceed with the complaint. If it feels that it is baseless, no action is warranted, it drops. Or it may make its recommendations to the government, and then the central government is obliged to inform the Commission of what action it has taken on the recommendations of the National Human Rights Commission. So therefore, this procedure contained in section 19 is to be borne in mind with regard to the relationship between NHRC and the armed forces. Within the armed forces itself, to observe and monitor human rights regime, the task has been given at the Army Headquarters level to the Additional Director General of Discipline and Vigilance, who is an officer of the Major General rank. Under him, there is a DDG DV Colonel Human Rights Cell, and then there are deputy directors, and this may also have a police officer belonging to the Indian Police Service within the directorate. At the level of headquarter commands, there is a discipline and vigilance cell, and also at the level of corps headquarters or at force headquarters, similar discipline and vigilance cell look after the matters pertaining to human rights. The human rights cells which are there at the level of command headquarters, corps and force headquarters of Rashtriya Rifle, they are meant to act as nodal agency for receipt of all allegations and complaints. Therefore, at the level of command headquarters, corps headquarters and force headquarters, all petitions which are coming or complaints that are received are forwarded to this cell, and they monitor human rights issues, and they also supervise that these allegations lead to prompt and proper courts of inquiry, and thereafter those who are defaulters or perpetrators of violations are dealt with effectively and suitable punishments awarded. A code of conduct observed within the armed forces, it lays down that HR violations must be avoided under all circumstances. Don't do it, don't be a part of it, and don't ignore it. Be compassionate in your dealing with the other citizens of the country. Be part of people-friendly operations. All missions conducted by the armed forces in the border areas along the line of control, international border, or in other areas should be people-friendly, and it must be ensured that the civilian population there is put to least possible inconvenience or harassment of any sort is avoided. Uh, while using force, if there is a need to observe rules of engagement, then minimum force doctrine is to be used, and collateral damage to the extent possible must be avoided. In operations, a police representative should be co-opted, or where needed, Mahila police rep should be taken. In the reports and dealings, be truthful and honest. And there is a policy called winning hearts and minds, which was being used and which is being used in Jammu and Kashmir, in the Kashmir Valley, and sustain moral and physical strength insofar as the troops themselves are concerned, and the citizens or the locals of that area. There is an Armed Forces Special Power Act which has been in vogue. It has been operating from 1958 onwards, and this, as the name indicates, has been framed to provide special powers to armed forces personnel who are deployed in the areas which are designated as disturbed or dangerous. And this designation can only be done where a requisition has been made by the governor of the state, or the chief commissioner of a union territory, or by the central government, and the use of force, deployment of force, has been agreed upon by the union government. So apart from giving powers to armed forces personnel of the NCO's rank and above, it also provides legal protection to the army personnel for the actions that they have taken while deployed on official duty in these disturbed or dangerous areas. The act has attracted certain criticism at various times. It has been alleged that it is being abused or misused. It results in harassment of civilians while the troops come out on missions in those areas. There are also complaints that certain fake encounters or extrajudicial executions have taken place in which the armed forces personnel participated, and if the civil administration wants to proceed against the armed forces personnel, then sanction is delayed and at times denied. There are three landmark cases with regard to the armed forces operating in areas where AFSPA has been invoked, and we would shortly see. There is one, Naga People's Movement of Human Rights versus Union of India. This is a 5 judges bench, and there are two decisions of 2 judges bench, division bench. One is Extrajudicial Execution Victim Families Association versus Union of India, and the second is Laure Bam Deben Singh versus Union of India of 2019. The 5 judges bench in Naga People's Movement of Human Rights in its 1998 decision indicated, we are just seeing the operative path, and that too, the gist, the court said that act is not a colorable legislation, it is not a fraud on the constitution, and the powers under section 4 and 5 of this act are not arbitrary and unreasonable. Now these three and also the fourth one are to be seen as if these were the responses of the judgment to the allegations that were discussed and that were argued before the court. And in 4, the court held that the act does not amount to handing over the maintenance of public order to the armed forces directly. So these were the pronouncements of Supreme Court in Naga People's case. Moving to extrajudicial execution, a decision of 2 judges bench which was authored by Justice Madan Lokur. It said that power to cause death of an enemy while on active duty has to be under definite circumstances as prescribed. In other words, what was implied was that the rules of engagement should be so designed by the armed forces which should clearly indicate as to what are those circumstances where the force used may cause death of an enemy. And mark the words, please, the use of the word here, enemy. And the court further said that there is a difference between right of self-defense and a situation where use of excessive force or retaliation has taken place, and there is no acceptance uh, as regards the later, that is use of excessive force or retaliation. In the last case of Lorembam Diben Singh, Uh, again, Justice Madan Lokur's decision, the ruling was whether alleged killing or death of large number of persons described was justified or not. That was the question that the court took up, and they said that this can only be decided during investigation by a special investigation team or the SIT. And further, the court remarked that it is necessary to know the truth so that law is tempered with justice. So, where there were conflicting versions by those who were victims of the Armed Forces Special Power Act, they came up and approached the court, and on the other hand, the armed forces. So, the court in that context said that it is necessary to know the truth, because then only administering law with justice would be feasible. And the excuse for knowing the truth mandates ascertaining in this situation whether fake encounters or extrajudicial executions had taken place. And the court said that if they had, then it was necessary also to consider who were the perpetrators of human rights violations, and how could the next of kin be commiserated with, and what further steps to remedy and rectify the practice of use of force needs to be changed. In this context, it would be useful also to recall a passage from the decision of the Supreme Court in the state of Rajasthan versus Union of India in 78, where the court remarked that it must be remembered that merely because power may sometimes be abused is no ground for denying the existence of power. In other words, there could be a scope to abuse the power, and the wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. Now, these are very wise words coming from the Supreme Court, and this would be helpful to remember these while talking about human rights violations. At the end of it, there are certain recommendations which are there in this presentation. It would be useful to introduce specific courses on human rights for all ranks of the armed forces. There is a necessity to have separate, clearly laid down manuals on human rights and international humanitarian law observance. The troops should be sensitized by way of war games, tactical exercises without troops, and workshops. It may be obligatory to co-opt a civil official, state government officer in every court of inquiry where investigation involves a death, serious injury, or sexual offense. Investigations taking place must be accessible to civil witnesses, and in all courts of inquiry where the inquiry is regard to a sexual misdemeanor, it may be useful to include a women officer. There are certain further recommendations which call for compilation of case studies that would help in better understanding and assimilation of law, amend military law provisions to introduce an omnibus section to cater for human rights violation. There is no specific section in the list of offences now. And lastly, the Judge Advocate General Departmental officers should be utilized in the process of recording of confessional statements from those who have been apprehended, or seizure memos prepared after an encounter and FIRs lodged with the civil police. In conclusion, it may be useful to consider that proper monitoring and follow-up action after probes on human rights violation is as necessary as close analysis of tactical missions, which Army usually and invariably carries out. Thank you.